Again, I'm the Assistant Attorney General tasked with working, or one of three, tasked with working on the litigation we have against the Census Bureau and the Department of Commerce et al. Regarding the citizenship question. Have you all been following it in the news a little bit or heard a teeny bit about it? Essentially, the census, as everyone has said and will say over and over for the next 2 years, is incredibly important, and it's tasked with counting every resident of the United States, regardless of their documentation status. So regardless of whether you're a citizen or whether you're a documented or undocumented immigrant, if you're a resident, you are supposed to be counted in the census. In early 2018, I don't remember the exact date, I think it was a news organization kind of broke a story that the Department of Justice had requested that a citizenship question be added back to the decennial census. There's a long history, and I now know many books written about the census, which look incredibly interesting, which document the history of all the crazy questions that have been on the census throughout US history. But my understanding, based on reading about these books, because I haven't read them yet, and histories and legal decisions, is that between the founding and 1950, in various 10-year periods, various forms of the citizenship-like question may or may not have appeared for various reasons, and it kind of ebbed and flowed, and what they were focusing on changed, and it's a complex history. But it hasn't been on the decennial census since 1950, and many of you may remember the long form census. So the decennial census is now very, very different because it's divided into the kind of short decennial census that everyone does, and then it used to be the long form, and now it's the ACS, and so it's a complicated kind of research methodology history. But DOJ asked that the citizenship question be put on the decennial census short form for voting rights enforcement purposes, saying that having citizen voting age population data at the block level was necessary to enforce the Voting Rights Act. In response to this, many advocates from nonprofit groups and organizations and social services providers were immediately incredibly concerned about the impact that would have on both non-citizens' response to the census and citizens' response, because many non-citizens live in households with citizens, and you, as a head of household or maybe a household member, will have concerns about reporting non-citizenship status of other people in your household. So there was an immediate advocacy push to try and get this not to happen. The AG's office, along with many other groups, including former Census Bureau directors, wrote letters to the Department of Commerce advocating against it, but ultimately the Secretary of the Department of Commerce decided to include the question. That was in March. Within hours, California had sued the Department of Commerce and the Census Bureau, and I think we were a week or two behind. A multi-state group, including, I think the last number I read was 19 states, counties, cities, and other kind of governmental entities came together and sued. We sued in the Southern District of New York. That's probably not interesting to you all, but there are a handful of cases in California, Maryland, and New York now. There's also, interestingly enough, a case in Alabama brought by folks there challenging the law that says you have to count non-citizens. And there's some concern that's been reported in the media that the federal government isn't going to defend that, so there's been kind of a motion to intervene by advocates for immigrant groups to defend that. So the cases are all making kind of some assortment of three claims. The first claim is a constitutional claim that the Constitution requires an enumeration of every single person, and by adding this question, you're reducing the likelihood of getting a proper enumeration, therefore you're impeding the constitutional purpose, is kind of the essence of that claim. The other big claim is what's called an APA claim, an Administrative Procedures Act claim, and it's essentially the claim that you're an administrative agency and you are tasked to follow the law and follow procedures and regulations, and we have all sorts of rules about how agencies make change and promulgate regulations, and you have to follow those, and you didn't do that here. And the third claim, which we didn't make, but a group of nonprofits that were consolidated into our case made, is the classic equal protection claim that says that we actually think that this isn't about voting rights enforcement, that it's about discriminatory animus, and the purpose is actually to deter people of color and people who don't speak English and non-citizens from being counted. So all three of those claims are somehow in the consolidated litigation that I'm a part of. We're alleging, I like the slide that said data, money, power, because those are exactly the harms we're alleging in the case. That first and foremost, the power piece, because the enumeration impacts representation both federally and statewide, because if you have an undercount in Boston and Springfield, the state legislature, the districting for that could also be off balance. It's not just between the states, it's intrastate as well. So that's the power piece. The money piece is funding and efforts like this, and all the Herculean efforts the Secretary of the Commonwealth is going to have to go through to try and get the best enumeration possible, and we've been working very closely with them, and they've been helping us a lot in this case. And then the data piece, which is just that this impacts everything we do. Medical researchers who study populations draw census data. Academic researchers do this. This is important. It's an important part of the fabric of our society, and it's really important that it be accurate. So those are actually our harms. So it's a perfect slide. So the first thing that happened, I'm going to try not to get too in the weeds on the litigation, but I just came back from the trial, and it's very exciting to me on a litigation nerd level. But the first thing that happened is the federal government filed a motion to dismiss to try and get rid of the claims completely. And we survived that motion. Our judge dismissed the constitutional claim, but allowed the APA claim to go forward, and the equal protection claim of the plaintiffs in the consolidated case. Interestingly enough, the judge in Maryland also allowed the constitutional claim to go forward, and it's really interesting, if you wanted to read their decisions side by side, because they really focus on very different histories behind the census, and they're both really interesting and compelling decisions and thoughtful. But I really like this, and I'm sorry to read this, but I thought I like the judge using the judge's own words. So in analyzing the equal protection claim, the DOJ allegedly said that they needed this data for voting rights enforcement, but the current Civil Rights Division of the DOJ has not been doing a ton of voting rights enforcement. That has not been a priority. And in all the years that there's been a Voting Rights Act, this question has never been on the decennial census. So no voting rights advocates have ever used this data or won a case with this data or needed this data to win a case. And so the court stated, there's no indication in the record that DOJ and civil rights groups have ever, in the 53 years since the Voting Rights Act was enacted, suggested that citizen data collected as a part of the decennial census would be helpful, let alone necessary, to litigate such claims, concluding that in appropriate circumstances, the trier of fact can reasonably infer from the falsity of the explanation that the defendant is dissembling to cover up a discriminatory purpose. Such an inference is consistent with the general principle of evidence law that the fact finder is entitled to consider a party's dishonesty about a material fact as an affirmative evidence of guilt. So that was what the judge concluded in allowing the equal protection claim to go forward.
That was in Maryland?
This was, no, our New York judge is the one that said that about the equal protection claim. So in conjunction with the motions to dismiss, we had a bazillion, technical term, discovery battles. Our court allowed what's called extra record discovery, so we got an expanded administrative record, and we got to get evidence from experts because of evidence of bad faith in the case. And our court also allowed us to depose the chief or assistant chief, no, I think he's the chief of the Civil Rights Division at DOJ, whose name is Gore, and Secretary Ross. DOJ appealed that all the way, well, they did the Second Circuit, and then they did the Supreme Court, and then they did it all over again 3 or 4 times. And so we never deposed Ross, but we did depose Gore. And lots of really interesting evidence was uncovered. There's a reporter who's covering it for NPR called named Hansi Lo Wong. And if you're interested, he has a Twitter feed. He's been live tweeting about the trial, which is where I've been getting my information when I haven't been there. And so I'm just going to list some really interesting pieces of evidence we didn't know before this litigation. Immediately after the administrative record was produced, Secretary Ross released a memo saying that actually the request to have the question wasn't initiated by the DOJ, but he had been thinking about it almost a year earlier. And at that time had talked to Steve Bannon and Chris Kobach out of Kansas about it. There are emails where Kobach talks about not wanting not to count non-citizens in the record. There are emails from Ross from months before the DOJ letter saying, why hasn't anything been done to put this on the census yet? That's paraphrasing, but pretty close. There's evidence that Ross went to DOJ and said, will you ask for this question to be added? And they said, we're dealing with too much stuff right now, we don't really want to. And then there were higher level conversations, maybe with the AG, and then DOJ agreed to ask for the information. We got a memo generated by the excellent scientists at the Census Bureau that said that they themselves estimated that there would be a 5.8, I think that it was 5.8 or around there, percent reduction in self-response as a result of this question, and that it would cost a lot of money to deal with it, and that they wouldn't recommend going down this path, that they, in fact, as the scientists at the Census Bureau, would recommend using administrative data, which is more accurate and cheaper, and they have tools, they're starting to get tools in place to use it for other things anyway. I saw testimony yesterday that somehow the Census Bureau answered a question to the Department of Commerce saying, when we change questions on the census, we go through a process and it involves testing, but the copy that was given and produced in discovery to us said that the Census Bureau hadn't changed the census in so long, they didn't have procedures they were committed to following, and the chief scientist didn't know where that answer had come from or why it was there, because it is not the answer that the Census Bureau in fact produced. And Gore admitted in his deposition that the data from the question was not necessary for the Voting Rights Act enforcement, and that former AG Sessions had directed them not to meet with Census Bureau staff about any of the other options for getting the data. So it's all very juicy evidence. Very quickly, before I sneak out, we submitted testimony from the CFO at EOHHS, Executive Office of Health and Human Services, documenting our specific funding harms in Massachusetts that might result from an undercount relating, we talked specifically about veterans grants and children's grants. There was lots of evidence in the case. We hired lots of amazing experts, including Thompson, who's the former Census Bureau director. And yesterday I saw the testimony from voting rights math lady. She's like a redistricting expert, and she's been hired by the DOJ before this administration as an expert in their voting rights enforcement, and she basically said, I don't need this data. Yesterday, their chief scientist at the Census Bureau, Dr. Aboud, testified, and he is an amazing scientist. And what's interesting about him is he testified both for us in support of the plaintiffs in the case, and he's testifying for the Census Bureau today as we speak. I expect it to end today or tomorrow, and there will be closing arguments. So all this to say that our goal, the plaintiff's goal in this case, is to get this question off the census. And we've represented to our court the time as of the essence, so this litigation has been done incredibly quickly because we want a decision this winter so that appeals can happen, so that we can have a ruling that this question will not go to the printers in June of 2019. And that we can prevent a lot of the harm that everyone is worried about by sending the message that we want everyone to be counted, and that it's safe to answer, and safe to participate, and that your states are invested in you being counted and keeping you safe and as part of our communities. So. I could say so much more, but I think that I will stop there, and I have like 1 minute if anyone has a question.
I think we need to say thank you.
Yeah. Well, I hope we have good things to report going forward. Watch the news. It should be happening all within the next few weeks or maybe a month. Because our judge has really been cognizant that it would hurt the defendants to have to make a late change and hurt us. The longer this is an issue, it hurts everyone. So he's been pushing it forward to try and get it resolved.
Thank you, Ann.
Thank you.
I just want to say thank you so much for that presentation. That's really helpful information, and that. Yeah, thank you for the work you're doing, and that's definitely been, as I'm sure many of you have been having that conversation and hearing about it in your own areas of work and life. And Allison and I were out in Boston last month for a meeting with the Massachusetts Census Equity Funds, with some groups that are working throughout the state and in the Boston area on this effort as well. And this was a topic that came up that I'm sure amongst this group, over time, if the question does not get removed, and I think even if it does get removed, it's a topic that we're going to want to talk about a lot in terms of how we approach the outreach that we do and deal with the concerns that this